Walker, and I'm the conference manager for today. If counsel on either side of the case or a judge drops from the conference, I will announce it and we will pause the proceeding and the clock. The dropped individual should attempt to rejoin as quickly as possible. Please just contact myself or Sarah Carmichael at the phone number listed on top of your court sheet if you had any trouble reconnecting. Judge Motz, it looks like the participants are ready to proceed. Can I have the courtroom deputy open court?
Yes, please. Thank you.
Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention. For the court is now sitting. God save the United States and this honorable court.
Good morning. We're happy to have you with us, even just visually, and we're happy to hear from counsel in our first case, number 197650, United States versus, you're going to have to help me. I'm not sure how you say this gentleman's last name. Ms. Larsh?
Thank you, Your Honor. I'm happy to appear today on behalf of the appellant, Mr. Spruhan.
Spruhan. Okay.
All right. Under the Sentencing Commission's policy statement in 1B 1.10, less deserving offenders are eligible to receive reductions in their drug sentences under 3582C2, but more deserving offenders are not. The policy statement also injects unwarranted sentencing disparities into the sentencing process by undoing a district court's relative weighing of culpability between co-defendants and co-conspirators. In Mr. Spruhan's case, for example, the district court gave him a sentence of 180 months. That was 2.5 years more than one of his co-defendants. But after that co-defendant was eligible for a sentence reduction and Mr. Spruhan was not, the gap between their sentences doubled to 5 years. The Supreme Court in Labonte held that where the commission has enacted a policy statement that conflicts with the authority Congress gave the commission by statute, the policy statement must give way to the Congress's directives. The eligibility bar in this case in 1B 1.10 that prevents defendants who received non-cooperation variances and departures from their guideline range from being eligible for a later reduction conflicts with the purposes, powers, and duties of the Sentencing Commission as Congress set it out in the relevant statutes. And there's two sources of conflict I want to direct the court's attention to today. The first is the way that 1B 1.10 conflicts with the purposes of the Sentencing Commission that are set out in 28 USC 991A. In that section of the code, Congress said that the Sentencing Commission can establish sentencing policies and practices that assure the meeting of the purposes of sentencing as set forth in section 3553A2, and specifically to avoid the unwarranted sentencing disparities. Now, we know that the Ninth Circuit was incorrect, and the government is incorrect in this case, to argue that these are merely aspirational purposes. And that's clear for at least two reasons. First, because Congress separately in section 995, which sets out the powers of the Sentencing Commission, specifically enumerated that the commission had the power to, quote, establish general policies and promulgate such rules and regulations as are necessary to carry out the purposes of this chapter. So the specifically enumerated powers that Congress gave the commission are directly tied to the purposes in 991A. So we've only had, of course, for an agency, powers that Congress has specifically delegated. In this circumstance, they're directly linked to the purposes. But there's a second reason that we know the powers, or rather the purposes in 991A are not aspirational alone. And that is because the word purposes needs to be-
Ms. Larsh?
Yes, Your Honor.
I assume that your view is that the Ninth Circuit's decisions in Padilla, Diaz, and Hernandez-Martinez are simply incorrect.
That is correct, Your Honor.
Okay.
And I'm happy to explain the two mistakes I believe the Ninth Circuit made. The first is that the Ninth Circuit held that the purposes of the Sentencing Commission in 991A were just aspirational, but they didn't consider at all the fact that the powers of the commission in 995 are directly tied to those purposes. And they also didn't consider the fact that the word purposes has to be interpreted consistently across the relevant sentencing provisions, which includes both the word purposes in 991A, but also the word purposes that already appears in 3553A2. Those are both statutes enacted as part of the Sentencing Reform Act in 1984. And we know, as a matter of common course, that the purposes of 3553 are not just aspirational for district courts. District courts are required to follow the purposes that are set out in 3553A2. And we should also expect that the Sentencing Commission is required to follow the purposes that are set out by Congress in 991. But there's another reason that I think the Ninth Circuit's decision should not be persuasive for this court, and that is because the Ninth Circuit fundamentally held that sentence modification proceedings under 3582C2 are acts of lenity that are unmoored from the typical concerns and policies of sentencing. And while that could be true in the Ninth Circuit, it is certainly not true in this circuit under this court's precedent. And the specific precedent I would direct the court to is the Martin case, which came after the Supreme Court's decision in Chavez Meza, and held that in a sentence modification proceeding under 3582C2, a district court is required to give enough robust explanation of why it decides to give a reduction or to not give a reduction, and consider the 3553 factors, including mitigation evidence a defendant presents, and that that's all relevant and required in a sentence modification proceeding. So it's not the case in this circuit that they're entirely unlinked. Ultimately, I think that the government and the Ninth Circuit in Padilla-Diaz overread the decision in Dillon to have it say something it simply did not say. Dillon was a narrow decision that determined that the Sixth Amendment right to a jury trial did not apply at a sentence modification proceeding. There are, of course, many kinds of proceedings where a jury trial right doesn't exist, and this is just one of them. Dillon doesn't say anything to tell this court how to interpret the conflict between the directives of Congress on one hand and the policy statement that the Sentencing Commission enacted on another hand.
Well, ma'am, the Supreme Court did say in Dillon that sentence reduction proceedings under 3582C are congressional acts of lenity intended to give prisoners the benefit of later enacted adjustments and are not sentencing or resentencing proceedings. Seems to me that's a clue as to how the court sees these two provisions affecting or not affecting each other.
That's correct, Your Honor. I certainly agree that that's the holding in Dillon, which makes sense considering that Dillon was deciding whether or not a defendant had the right to prove new variances at a sentence modification proceeding. But it doesn't speak to the notion of old variances that the district court already found, to the individualized determination that a district court already made. And in fact, when Dillon speaks of affirming the general principle that a district court should strive to isolate the impact of the guideline amendment and leave all other determinations intact, it would suggest instead that all the original determinations the district court made should be carried over, including those original variances and departures, that that's the spirit of Dillon, and that Dillon is simply talking about not having a new proceeding where a defendant has an opportunity. I'm sorry, it looks like you have a question, Your Honor.
No, I was just going to say, but of course, Dillon doesn't say that.
I agree, Dillon does not say that. I think that that's the spirit of what Dillon is saying,
Right.
that it's directed towards new variances, not towards variances the district court has already found. And I want to discuss one other area of conflict in the statutory framework that I think is relevant to this court. And it's the same statute, ultimately 994, the statute that sets out the duties of the Sentencing Commission that the Supreme Court found was problematic in Levante. And I would direct the court to 994 in the very beginning of the duties of the commission, specifically include under subsection A, promulgating and distributing both guidelines and policy statements that are consistent with all pertinent provisions of any federal statute. That is a baseline requirement for anything the Sentencing Commission does. They must be consistent with other federal statutes. In this case, of course, the federal statute that I think causes the problem and the tension is 18 U.S.C. 3553, which sets out the requirement that sentences must avoid unwarranted sentencing disparities. So I think this is a separate area. And ultimately, the government and the Ninth Circuit suggest that the later part of 994, specifically 994U, sort of overrides these other parts of the statutory framework. That because I'm sorry, Your Honor.
Sorry, can I interrupt you one more time?
Please.
Has any court ever held that 991B applies to 3582C proceedings?
That 991B, specifically that part of the purposes, Your Honor?
Yeah.
No, I'm not aware of any court that has specifically, the only court I'm aware of that specifically considered the issue of whether 991B applies is the Ninth Circuit in the Padilla-Diaz and then later Hernandez case. But no, Your Honor, you would be the first to so find.
Okay, Ms. Lahr, since we would be the first to so find, how would you develop the rationale behind that? In other words, are we required to hold that 991B is a mandatory directive in order to get where you want us to go within an aspirational statement? And if so, how do you develop that rationale in an opinion? I always like to think of how we're going to write it if we're going to adopt your perspective. So how would you develop that?
Of course, Your Honor. I would suggest that the court would develop it in this way, that it's important for agencies to know what they're bound by and what they're not bound by when Congress sets out statutes, giving them authority and giving them a role to play. So we should err on the side of assuming that when Congress says something, that's what the Congress wants the agency to do. So when Congress sets out the purposes of the very existence of the Sentencing Commission in 991A, it expects the commission to comply with those purposes in all of the things the commission does. And so because the court should rely on the language from Labonte, which looks for the plain meaning of the language in the statutes and compares that to the language of the policy statement. And when there is a conflict, then the statute has to be the one that obviously trumps the policy statement. So I would suggest that the court would find that 1B 1.10 conflicts with those purposes and that those purposes are not just merely aspirational. And I would note that the Sentencing Commission themselves, Your Honor, does not think that they're merely aspirational. The Sentencing Commission said specifically that it was trying to avoid unwarranted sentencing disparities when it implemented the amendment to 1B 1.10. It specifically said that in its explanation for what it was trying to do. So even the Sentencing Commission does not think that it can do whatever it likes to do. I think it would be a very clear case, and I doubt the government would even argue this case, if the Sentencing Commission had said in 1B 1.10, when a district court goes to implement a sentence modification under 3582C2, it should affirmatively create new sentence disparities. If it said, go ahead, we want you to create disparities, and we want you to ignore the nature and circumstances of the offender, and we want you to ignore the nature and circumstances of the offense, that would be a clear conflict. I don't think anybody would argue that. Here we have the same result without the language, and this court should find that where there's the clear result, as the Ninth Circuit found in its case, that were sentences that were initially tailored to avoid unwarranted disparities and to account for individualized circumstances end up converging at the low end of the amended guideline range, that same result is still a conflict. And so I think I did want to also, let's see, have a little bit of time left, just go back to why I think it can't be the case that 994U trumps everything else. And 994U is, of course, where Congress told the Sentencing Commission that it could determine the manner and the amount of a reduction a defendant is entitled to by setting out a policy statement to govern 3582C2 proceedings. But I would suggest a relevant analogy for the court to consider from my own life, for example, is how I might delegate authority to a babysitter and say, my children can have snacks, but those snacks have to be fruits and vegetables. And then if I have another policy and tell the babysitter, you can decide what time of day is snack time, you can decide how many snacks they get and how much they eat, but those policies still have to be consistent. The fact that I tell the babysitter, you can decide the amount and the timing of the snacks doesn't obviate and rather supersede the prior policy that I've set into place. And here, when Congress tells the Sentencing Commission, you get to figure out the manner and the means of these reductions, it doesn't mean that they can ignore the prior specific delegated authority to avoid unwarranted sentencing disparities and to respect the other purposes of sentencing. So I think that they have to be read together. And I would suggest it's particularly important that this court be the one to review the policy statements that the Sentencing Commission has set into place in this instance, because of course, policy statements don't have other review. They don't go before Congress for notice and comment. Congress has no part of the role here. If the Sentencing Commission exceeds its authority, it's only the court that can say so. And so I think that it makes it particularly important to have judicial review, and a reason for this court to apply Levante, a very clear precedent in this circumstance. If there are questions, I'll reserve the remainder of my time for rebuttal. Thank you.
Thank you very much. Ms. Hudson?
Thank you, Your Honor, and good afternoon. As in response to my colleague's argument, I would just start with the plaintiff's statement, which I think is that the government thinks that the Ninth Circuit in Padilla-Diaz and Hernandez-Martinez got this exactly right. As the court, I think, is well aware, that court had two reasons for its decisions. The first being that 991 was a general statement of the commission's goals. It was not a specific directive like the one that was at issue in the Levante case. And we, of course, agree with that. I would point out in response to my colleague's arguments that the Levante case referenced also Stinson, an earlier Supreme Court case that made even more clear that the commentary is authoritative unless it violates a constitution or statute or is inconsistent with or a plainly erroneous reading of a guideline. And we think that Levante is clearly, for those reasons, distinguishable from the issue in this case. 991 is not a specific directive like the language that was at issue in Levante. It is not a statement to which all sentencing policies must conform, and the Supreme Court's decision in Dillon, we would argue, makes that especially clear, where Dillon, as Judge Motz has already pointed out, clearly stated that 3582 proceedings were congressional acts of lenity. They are limited adjustments to otherwise final sentences, and I would say they are just different.
Along that line, can I ask you, are there any statutory or constitutional constraints on the commission's ability to promulgate policies relating to sentencing reduction?
So I think the provisions that we've talked about, and when I say we, I mean my colleague in her argument with the court, certainly the foundation for this argument is 991B, which are the purposes. The government is certainly not saying that those purposes are meaningless. They are what they are. They are a statement of the purposes of the commission and the guideposts for the commissions to develop policies accordingly. 994
but
is the
according
government.
according to the government, there's no check on whatever the commission decides is the correct policy. Is that what you're saying?
I think the check is the limitation that we've discussed in Levante, which is if there is a head-on collision, if in fact the as broad as the discretion is, if it must bow to the specific directives of Congress. So if it is not a specific directive here, then I don't think there can be the kind of head-on collision that caused the court to reach the ruling that it did in Levante. Levante said if the language is at odds with the statute, it must give way. And perhaps I can argue that regardless, the commission's language, I think when you look at the reasons that the commission stated for the amendment and for the policy statement that it developed, it was consistent with 991 regardless. So, I mean, the commission's language, in my view, could not have been more consistent, quite frankly, with the guideposts that were set there by 991, if those in fact were considered to be a specific directive. When the commission said that it had determined in the specific context of 1B1.10, a single limitation applicable to both departures and variances furthers the need to avoid unwarranted disparities and avoids litigation in individual cases. That ties directly back to 991B. They further went and said that the limitation that prohibits a reduction below the amended guideline range in such cases promotes conformity with the amended guideline range and avoids undue complexity in litigation. And then they get to the exception that they carved out for 5K defendants and said that the guidelines and the relevant statutes have long recognized, I won't read it all, the differences between 5K defendants who have cooperated, and noted that they are differently situated than other defendants and should be considered for a sentence below a guideline or statutory minimum, even when defendants who were otherwise similar but did not cooperate are subject to a guideline or mandatory minimum. And the final sentence underscores this point further when they said that applying this principle when the guideline range has been reduced and made available for retroactive application under 3582 C2 appropriately maintains this distinction and furthers the purposes of sentencing. So in the government's view, the commission could not have been more clearly following the guidance or purpose statement or goals, expression of goals that are contained in 991B, and only if the guideline or commentary language directly conflicted with or violated the statute would we have the kind of head-on collision that the court found problematic in Labonte. We just don't have it, whether it's because it's not exactly a directive or 3582 is different and is not constrained by 991B or the general sentencing policies, which is the argument that we make, or alternatively, because in fact, the commission's language is not inconsistent with 991B. For any of those reasons, I think the government should prevail in this case. But I think that the Ninth Circuit in Padilla-Diaz did in the most straightforward manner, and I guess the only manner that we've had an opportunity to review, because I do not know of any other courts either other than those out of the Ninth Circuit looking at this issue. We think the analysis from that case is the appropriate analysis in the two-pronged nature of that decision, first addressing whether 991 is a specific directive, and secondly, whether 3582 is in fact an act of lenity and different from other sentencing proceedings. You
don't have to use all your time.
Well, if that is a clue, I might stop. I think I would add one thing before perhaps I stop in response to the citation in my colleague's argument to the Martin decision. I think what I would like to say in response to that is that the fact that the court is required to give some explanation to explain itself in the context of 3582 does not translate that proceeding into a full or even plenary resentencing. And again, Dillon's statement that 3582 proceedings are different, that they are simply acts of lenity and allow limited reductions to otherwise final sentences, I think still carries the day and would argue against Martin having any impact on this case. Otherwise, with regard to the rest of counsel's arguments, I think we would rely on our brief. Unless there are any further questions, I'd be happy to answer.
I don't think we have any. Thanks very much.
Thank you.
Is there a rebuttal?
Yes, Your Honor, thank you. So I'd like to start by pointing out the tension in the government's argument. On one hand, the government asked this court to find that the purposes that are set out by Congress in 991 are not meaningless. But on the other hand, they're also not directives and they're not binding. But then at the same time, while the commission did try to follow those same purposes and policies, and so we shouldn't be too concerned. So I think it has to be one or the other. Either those purposes are binding and they have some, and that this court has the ability through judicial review to say that policies or guidelines that are enacted by the commission are conflict with those purposes because they have some actual teeth to them. or they mean nothing. And there was really no reason for Congress to write them down in the first place. But I don't think that there can be room for a middle ground. They either have to mean something or they don't. And I think that the government's suggestion that, well, the commission was trying to follow the purposes set out in 991B, so we shouldn't be too concerned, there's no direct conflict. That focuses on, of course, the language the commission used at the time it amended 1B 1.10, but ignores the actual impact. And the Ninth Circuit itself has discussed the impact and found that the impact is concerning, that it undoes the individualized determinations a sentencing court makes, and that it doesn't, it basically takes sentences that initially avoided unwarranted disparities and undoes that tailoring the district court did. So that's the impact of the guideline. The commission's rationale that it stated should be understood in the terms of what the amendment was trying to do. Prior to the amendment, 1B 1.10 distinguished between defendants who had received below guideline departures and defendants who had received below guideline variances, for who might be eligible to then still receive a proportionate below guideline reduction for the 3582 C2 sentence modification. And as this court is well aware, everyone confuses departures and variances. And so that produced a lot of litigation where people were trying to argue that it was a departure, not a variance, and that was confusing to district courts. And so when the Sentencing Commission said we're trying to make things simpler and to avoid litigation, they were getting rid of that distinction. But then they created another distinction that has produced the disparity at the heart of this case. So the Sentencing Commission's rationale that my colleague has pointed to need to be understood in that context. And then the actual product of the policy is what this court should find conflicts with Congress's directives. I would lastly just go back. Yes.
Ms. Larch, could I ask you, it seems to me that there may be, and I'd like you to address, maybe a flaw in your argument as to at what level are we looking at the commission's statement of policy? In other words, are we looking at this from 5,000 feet where it's an overall directive, a best practices goal, or are we looking at it with the level of granularity that you're suggesting that it has to conform in each and every case to the specifics of a defendant's sentence? And that seems to me to be the flaw in your argument, that a broad statement has to fit every single case with the particular sentence imposed by the district court, whether previous favorable treatment had been given, and how can that possibly be?
Well, Your Honor, I think that the key thing for the court to consider in forming its opinion in this case is that this is an eligibility bar. And where we're talking about a categorical bar where people are not eligible at all to go to the district court to argue their individual circumstances, to make their case for why a reduction may or may not be appropriate, that is where the if it creates, not just for Mr. Spruham, but for an identified class of people, this disparity, this removal of a district court's previous individualized determinations, that is where this court should exercise its oversight and find the conflict. And it's critical to, I'm sorry.
Let me follow up if I could. Why, and I'm very sympathetic to many respects of your argument, but what I'm struggling with is why couldn't the commission have decided that to promote consistency, people should only get really one treatment that could bring them below the amended guidelines range? And if you got that treatment in your original sentencing or you got that treatment later on, it wouldn't really matter. We just want to make sure that everybody gets one shot at a sentence reduction. And I know that means that some people are going to be treated apparently less favorably on the individual level, but why couldn't they look at that from an overall basis? Everybody gets one shot.
I see my time has expired. Is it all right if I answer?
Yes, you can answer the question.
Thank you. Well, I think, Your Honor, the answer to that question is that the guidelines play such an important role in sentencing, which has been affirmed by the Supreme Court in the Molina-Martinez decision and also the Hughes case, as providing the anchor for sentencing that it's not enough to say that you had the opportunity to argue for variances and departures once. Given the anchor that the guidelines provide, even for below guideline sentences, and in this very case, the district court did hold in its opinion below that the guidelines played a role in determining the sentence, in this case, the below guideline sentence. Given that role, it's not enough to say, okay, well, you had one opportunity, because if the guidelines have that anchoring force, which this court has consistently held that it does, and then the guidelines are shifted down, it should only be appropriate for the district court, consistent with all of the practices and purposes of sentencing, to be able to consider the lowered anchor in constructing what is an appropriate new sentence and whether or not a reduction is appropriate. Thank you.
Thank you. Thank you for your argument.
Thank
We
you.
will take the case under advisement. We appreciate the arguments of both counsel.
Thank you.
We're happy to hear argument in our next.
Mr. Allen, turn your camera on.
Yes.
And Mr. Bowman, you can unmute when it's your turn, okay?
Good afternoon. May it please the
Good
court.
afternoon.
Good afternoon. May it please the court. I am Glenn Allen, the plaintiff and appellant in this case. I'm also an attorney admitted in this court and will be arguing my appeal. But I'd like to mention with respect the presence here at this Zoom location of my co-counsel, Frederick C. Kelly III.
Can you talk up just a little bit,
Yes.
Mr. Allen? Maybe you'll have to sit down. I don't know. It's hard to hear you.
I see. I'll just raise my voice a little, perhaps. Can you hear
Perfect.
me better now? Pardon me for that. I have reserved 5 minutes of my time for rebuttal. All litigants who appear before this court consider, and properly so, that their cases are important. But I submit respectfully that this case is extraordinarily important, not merely for its consequences for me, which are significant, but more momentously for its impact on fundamental principles of freedom of expression and the rule of law. As explained in our briefs, this impact has many aspects. For purposes of this oral argument, and without waiving any of my arguments in our briefs, I'd like to focus on 4 of these aspects: the Bartnicki issue, the Walker issue, the Food Lion issue. The Bartnicki issue, the Food Lion issue, my defamation claim, and my RICO claims. At the outset, I propose to provide a very brief summary of my case, unless the court finds that unnecessary. In December 2018, I filed my complaint alleging 9 claims against the Southern Poverty Law Center and 2 of its officers. My complaint describes with particularity the theft in May 2015 by one Randolph Dillaway of confidential and privileged documents from the National Alliance, in violation of Dillaway's fiduciary obligations and his confidentiality agreement, and the SPLC defendants' involvement in and exploitation of that theft. My complaint further describes the SPLC's publication in August 2016 of a widely disseminated article that used some of the Dillaway stolen information to orchestrate my firing from the Baltimore City Law Department, where I worked as an independent contractor attorney, and their later publication of a hate map in which they falsely stated that I had been, quote, infiltrating the Baltimore City government with so-called neo-Nazi ideology. My complaint also placed my claims to myself in the larger
Mr.
context.
Allen?
Yes.
Mr. Allen, did I understand you correctly that you were not going to address your argument on count 1, the declaratory judgment portion?
That's correct, Judge Adji. I would be glad to if you wish me to. I do have limited time, and I elected to not address it unless you request that I do so.
I do have a question or two about that particular count. Assuming that you are entitled to proceed with the filing of that suit, and that you're not barred by the Tax Injunction Act or the provisions of the Declaratory Judgment Act, there's still a question of standing. You're standing to bring that claim. And I had 2 questions in that regard. One was, as we all know, you have to have an injury, and I wasn't really sure as to what the injury was with regard to count 1. In paragraph 132, you make the statement that resolving the questions about the 501c3 status will serve the useful purpose of clarifying the legal relations between the defendant and yourself. Is that what you contend is the injury?
Judge Angie, yes, it does. I have a Damocles sword hanging over my head with the SPLC's propensity for doxing people and shaming them in public. I don't know when they might do that again. And I'm still active as an attorney. So the injury I am subject to is this instability and uncertainty that I might be attacked again in the future, which would affect my ability to pursue my profession as an attorney.
Well, along that line, as I understand your complaint, you do not either ask as a form of relief or allege that the 501c3 status should be revoked.
That's correct, Your Honor, and I understand it's an intellectual challenge to separate those things. I did cite to the Zimmerman case, which I think you took note of, in which courts have somewhat repeatedly, in the context of the Credit Repair Act, addressed the issue of whether an organization that purports to be a 501c3 is in fact acting as a 501c3, and indicating that this wasn't an attempt to undercut their standing with the IRS. It was simply an attempt to determine whether they are what they claim they are. And yes, that is where I'm drawing the line.
Well, if we assume there's an injury, there's a separate standing requirement as to remedy.
Yes.
And without the revocation of the 501c3 status, I'm not sure what remedy the court could give you here.
I appreciate that question, and I know it came up in the Freeliani case, as you're no doubt aware of, Judge. The remedy, I think, of a declaratory judgment would, I assume the SPLC as a law firm would comply with the instructions that came from the declaratory judgment to trim its behavior and comply in the future with the requirements of a 501c3, and that would be the remedy. I'm assuming that the SPLC would change its behavior.
Okay, thank you.
I was describing my case, and I mentioned that my complaint places my claims in the larger context of the SPLC's decades-long fraudulent, unethical, and unlawful conduct toward a myriad of other victims. The district court dismissed my complaint in November 2019 with prejudice on Bartnicki, Food Lion, and other grounds with no opportunity to amend. Let me then turn to the Bartnicki issues. The court will recall that in Bartnicki v. Vopper in 2001, the Supreme Court addressed the difficult question of the protections, if any, that the First Amendment provides to the publication of information that was obtained, at least initially, unlawfully or improperly. On the facts in Bartnicki, the court held that where the defendants had not participated in the initial unlawful acquisition and had lawfully acquired the information thereafter, even though it had been initially obtained illegally by a stranger, that the First Amendment shield was appropriate. Several circuit courts have addressed this, and this would be the first opportunity for this court to address that important issue. Essentially, to properly invoke Bartnicki as a First Amendment shield, and I'm citing to Justice Stevens' majority opinion, there are three prongs that need to be satisfied. First, the defendant publisher played no role in the initial theft or illegal acquisition. Second, they lawfully acquired the information, even if it was illegally initially obtained, and the subject matter of the interception was a matter of public concern. The SPLC defendants fail all three prongs. Let me first address the second prong, which I believe provides the most incontrovertible reason that the SPLC's reliance on Bartnicki is faulty. The allegations in my complaint, and specifically those at pages 34 to 37 of the joint appendix, describe with factual particularity the SPLC's unlawful acquisition of the information on the 6 thumb drives that Dillaway stole from the National Alliance on or about May 3rd, 2015. The SPLC's conduct violated numerous criminal statutes, including the Alabama statute prohibiting receipt of stolen goods, the Alabama statute prohibiting bribery of a fiduciary, and the federal National Stolen Property Act and the Travel Act. It also violated numerous canons of legal ethics to which the SPLC as a law firm is subject. an IRS regulation governing 501c3 profit. In short, there were multiple levels of unlawful, unethical, and improper conduct by the SPLC in acquiring unbroadened information. And therefore, manifestly, it failed the first prong, but also failed the first and third prongs. The first prong concerns the first step, the SPLC's involvement in Dillaway's initial theft. The district court held my complaint inadequate on that because I hadn't alleged with specificity the interaction between the SPLC and Dillaway prior to May 5th or May 6th, when the SPLC acknowledges having received thousands of pages of documents from Dillaway. But my allegations are entirely consistent with the likelihood that Dillaway and the SPLC defendants communicated and cooperated before May 6th, 2015. They had the motive, they had the opportunity, and they certainly had the resources. The pleading obstacle confronting me is that I am not privy to the secret communications between Dillaway and the SPLC. Only through basic elementary discovery can I learn of these communications. The district court, unfairly, I believe, dismissed my complaint with prejudice without giving me an opportunity to get into discovery. Finally, as to the Bartnicki elements, I would like to address the issue of matter of public concern. I'd like to quote a short excerpt from the Supreme Court's 1967 decision, the Haitian Board of Regents, in which the court addressed the inferences that may properly be drawn from a person's membership in an unpopular party, consistent with our traditions and our constitutional cases. In that case, the Communist Party. Justice Brennan from the court said, and I quote, "Under our traditions, beliefs are personal and not a matter of mere association, and men in adhering to a political party or other organization do not subscribe unqualifiedly to all its platforms or asserted principles. Justice Brennan's admonition teaches caution in attributing to me the views ascribed to the National Alliance, which I have no doubt the court finds highly offensive. One can, in fact, insert in Haitian and all the important First Amendment cases by Holmes and Brandeis and Brennan and many others, a willingness to give people generous space to experiment with different viewpoints and perhaps grow out of them into wiser people. For this reason, it's relevant, I think, to the public concern issue that the documents linking me to the National Alliance, membership of the National Alliance, were from 13 years and in one instance over 30 years prior to the SPLC 2017 article. I would make two further points on the public concern issue. First, I was not a person in a position of power as the SPLC claims. I was an independent contractor attorney at the lowest rung of the law department's hierarchy, who was quietly and ethically performing an illegal task assigned to me. And second, the SPLC's use of my involvement in the Burgess litigation to fabricate a public concern issue was illogical and dishonest. The SPL's tactic was to concoct a public concern issue that it was scandalous that a well-known neo-Nazi could be trusted to represent the city, given that the plaintiff, Burgess, was African-American. But I was representing the city of Baltimore, which is predominantly African-American, whose leadership is predominantly African-American. I was trying to achieve a litigation victory for the city and save it millions of dollars, and I was doing it effectively. Moreover, to support its bogus public concern issue, the SPLC, in its August 26 article, claimed I was, quote, a well-known neo-Nazi lawyer. But later, in their 2017 hate map, they said the exact opposite. They said, quote, nobody knew of Allen's involvement with white supremacist groups except for us. The SPLC has no scruples about saying one thing in one place and the opposite somewhere else if it serves their ends. It has cynically and maliciously looking for a pretext to destroy me and in that process fundraise to add to its millions, and to that end it concocted a public concern issue where none existed. I would turn now to the Food Lion issues, which relate to my state tort law claims. Not counting my defamation claim, I had 4 state law tortious claims, 2 tortious interference claims, a restitution claim, and a negligent training claim. The district court held all my tort claims to be barred by Food Lion because, according to the court, I was seeking, quote, defamation type damages under non-reputational tort claims, and therefore state tort liability cannot attach unless Allen shows the defendant's statements are false. This holding is ill-founded for at least 3 reasons. First, on the authority of the Supreme Court's 1991 Cohen v. Coles media case and the Food Lion decision itself. If the Food Lion doctrine applies at all to my tort claims, it does not apply insofar as I alleged occupational damage, which my complaint does repeatedly by identifying my termination from my position at the Baltimore City Law Department as a separate component of my damages. My complaint, in fact, alleges these separate occupational damages 7 different times. Second, not all tort claims that involve harmful disclosure of confidential information are defamation type claims that require proof of falsity. Also, there are obviously many examples of this. For example, if you induce someone to breach their confidentiality agreement, that is tortious, even if the material taken from the confidentiality agreement happens to be true. So it is illogical to require falsity in that context. Third, even assuming the Food Lion Doctrine applies and my complaint must allege constitutional malice, as to my tort claims, my complaint does so. One of the major themes of the SPLC's August 2016 article is that because of my supposed bias and racism, I was incapable of competently and zealously representing the city of Baltimore in divergence in which the plaintiff is African American. But presenting this narrative that SPLC ignored evidence it knew showed its narrative was false, namely evidence that I had zealously and competently represented African Americans in the Lloyd case. And in the Maryland District Court in the Wayne case, Maryland Court of Appeals in the Wayne case, I had helped create a scholarship for Native American students in it and mentored an African American youth through high school. Cherry picking evidence that suits their narrative and ignoring contrary evidence was held to be a basis for a finding of constitutional malice in the Supreme Court's Hart-Hanks v. Canopy case. And it shows the SPLC's constitutional malice as well. I turn now to my defamation claim, which is count 8 of my complaint. At the outset, I need to clarify that my defamation claim is not based on the SPLC's August 2016 article that led to my termination from the Baltimore City Law Department, but on the SPLC's later publication of its so-called hate map. The district court became confused on this point, directing its defamation analysis mostly to the 2016 article, insofar as it focused on the hate map at all. The court's analysis was brief and superficial, simply dismissing the hate map statements about me as mere, loose, figurative, or hyperbolic language. But both the stature of the SPLC defendants and the words they employed rule out a hyperbole defense. Let me read what the hate map says about me from page 122 of the joint appendix.
Counsel,
yes.
You are over time.
Okay.
Just take, if you would maybe wrap up.
Okay, sure. I would just point out that the hyperbole makes no sense in this case because of the gravitas of the SPLC, which is a 501c3 law firm and would be received as a reliable source. And I cite to the FLAM, the American Association of University Women case, which I cited in my brief.
Thank you very much.
Thank you.
We'll hear from the other side.
Thank you, Your Honor. May it please the court, Chad Bowman on behalf of the Southern Poverty Law Center, or SPLC. Your Honor, this lawsuit asserts claims over the receipt and publication of truthful information on a matter of public concern. That lies at the heart of First Amendment protection. And here, the context of litigation also is litigation by a political opponent. The district court properly determined that all claims failed as a matter of law, and we respectfully ask that this court affirm that ruling. Now, the facts here alleged in the complaint are fairly straightforward. A person named Mr. Dillaway had an altercation at the compound of the National Alliance on May 3rd of 2015. Took documents, was escorted off the grounds by police, and went to the Southern Poverty Law Center, as well as law enforcement, on May 6th, 2015. Turned over a set of those documents, copies of those documents, and the Southern Poverty Law Center wrote a story about it in 2015, because the National Alliance had long been one of the leading, if not the leading, neo-Nazi organization in the United States. Its founder left the American Nazi Party to found the National Alliance, wrote the Turner Diaries, and it was the National Alliance at this point was attempting to resuscitate itself after having fallen on hard times. The Southern Poverty Law Center wrote this important story of public interest. And then a year later, when Mr. Allen was working for the city of Baltimore in a public role, wrote a story asking a question about whether it was appropriate for somebody with a long ties to an organization that multiple circuit courts in this country have recognized espouses violent and racist ideology, and in fact has published works that the New York Times reported a couple of weeks ago following the Capitol attacks have been cited as motivating at least 40 terrorist incidents in the United States or hate crimes. Ask the question, is this appropriate given Baltimore's history for this individual to be in public service? In other words, Your Honor, what the Southern Poverty Law Center did here is it gathered information from a source about a matter of public concern and published it. And that is precisely what news organizations do all over the country every day. I'd like to talk a little bit about the Bartnicki issues that Mr. Allen raised. The important thing to remember about Bartnicki is that the wiretap statute at issue in that case, both federal and state law, didn't just bar the unlawful recording of voices, the unlawful wiretap. It also barred the disclosure of those wiretaps. And so the source, Mr. Yoakum, who gave that recording to the newspaper, violated the law. The newspaper violated the law when it published it. And what the Supreme Court said in that case is that the Daily Mail line of authority, striking down other laws barring the disclosure of information, whether that was a Florida Daily Mail case, whether it was the Florida Star case, says that so long as the publisher does not participate in the illegal act of acquiring the information, physically acquiring it, then the First Amendment protects the receipt of that information and dissemination of that information. It's not unlawfully acquired if the source is supposed to keep something secret. That happens all the time.
Can I ask you along that line, counsel? Suppose the government had brought criminal charges against your defendants for receiving stolen property. Does Bernanke protect you there?
I think so, Your Honor. I think that
they would have, receiving stolen property is a criminal offense, even in Maryland.
But as Judge Wilkinson noted in his concurrence in the Morrison case, there is a significant First Amendment question about whether the press could constitutionally be prosecuted for receiving information on a matter of public concern. Now, fortunately, there are some nuances here. The documents themselves were copies, as the counsel pointed out. It was akin to a leak situation where you have electronic copies of underlying records. But what Mr. Allen essentially is arguing is the private contractual guarantee or ethical rules somehow make it unlawful to acquire that information, when in Bartnicki and all of the other Supreme Court and authority cited in the briefs find that even a statute, a criminal law on point, cannot trump the First Amendment interests in the receipt of information about matters of public concern, so long as the news organization, the publisher itself, didn't participate in the illegal collection of that.
Well, counsel, how broadly would you say that Bartnicki applies? And the reason I ask that is that that was a 6-3 decision, but there was a concurrence by Justice Breyer and Justice O'Connor that gave the majority a majority, and that concurrence seemed to cabin the Bartnicki holding because they say in the concurrence that they would not extend that holding beyond the present circumstances. So that being the case, how specifically does Bartnicki protect your client here?
Your Honor, I would point out that Justice Stevens did write for the court. I agree the concurrence spoke of a balancing test, and I would take that on. I think that the Stevens rule, the majority rule, is controlling. I think it is in line with prior precedents and in line with what circuit courts around the country have done interpreting Bartnicki since, including the Jean case. But even if there was a balancing test, what the majority said in Bartnicki itself is that it is perhaps mundane, the negotiation over the high school teacher salaries in this one small district, but it is nonetheless a matter of public concern. And in that context, that trumps the ability to protect the privacy of these people having a phone call because there's a matter of public concern and the publisher didn't break the law. Now, there may be a remedy against the person who did the illegal wiretap. There may be a remedy against Mr. Dillaway if he in fact broke obligations with the law in stealing the documents. But punishing the press in this situation is no different than arguing that the New York Times should be sanctioned because it publishes documents that were posted by WikiLeaks, or any other publisher should be punished for revealing information that a source should not have shared. They do. Sources do share that information, and our position is the First Amendment protects it.
So, but what I'm trying to get at, and maybe my colleague was too, is first of all, in the hypothetical I posed to you, the clients were, the people receiving it were violating the law. That's part of the hypothetical. But let's take it a step further. Suppose that they had advertised. If you have any bad information about people that we are politically opposed to, we'll pay you $10,000 per story. So not only are they going to receive information that is stolen, but they're going to have paid for it.
Right.
They're still protected by the First Amendment?
Your Honor, I think the situation you outline is much closer to inducement of a crime. It's much
right.
closer to
well, but we
participation.
In the hypothetical, the crime is accepting stolen goods.
Right.
They know that.
Yeah.
I'm not saying that's your case necessarily. Let's just assume first that it's hypothetical.
I understand, Your Honor. I would answer that the constitutionally significant question is whether the information was stolen before or after it was offered to the publisher. The constitutionally significant question is, was the publisher involved in the theft? If I say to you, I'll give you, in your hypothetical, I'll give you $10,000 if you steal X for me, that's involvement in the theft. If somebody has hacked a server, as in the TNC case cited in the papers, or someone has already stolen information and goes to the press and says, I have this information, it doesn't matter that you knew that it was stolen. Under Bartnicki and Florida Star and that line of authority, the information was done, the theft occurred before the publisher became involved. And I think under that situation, the publisher can accept that information on a matter of public concern.
But as you say, if you advertise that you're going to give a reward, even if it's before the thing is actually stolen, or even after it's actually stolen, you don't know it's stolen. That makes it a little murkier.
Sorry, Your Honor. I do think that gets a lot closer to inducement, but what I will point out is the allegations in this complaint, Joint Appendix 35 and 36, are very clear, and they include those such allegations. And in fact, in the briefing, Mr. Allen made clear, and as he did today, that he does not know. He has no good faith basis to allege that the Southern Poverty Law Center somehow conspired with Mr. Dillaway before his confrontation with the allegedly armed individuals on the compound on May 3rd of 2015 and left, escorted by police. There's no allegations of that. And so the constitutionally relevant question of whether SPLC was involved in the actual theft is a question that is not raised by this case. Just a couple words about a couple of the other prongs that were discussed during the opening section of the argument. This idea that the Southern Poverty Law Center has additional duties because it has a law firm. The Supreme Court is clear that states can regulate attorney speech that has a significant likelihood of prejudicing legal proceedings, but even attorney speech is protected by the First Amendment. And here you have a situation where the Southern Poverty Law Center does pursue public interest litigation, but its intelligence project is entirely separate than that. It's a publisher. It used to publish in a publication called Klan Watch, that's now become Hate Watch, as the hate groups it monitors have grown. But it is a publisher, and it follows and reports on hate groups and radical groups in America. And it's no different than organizations like the NAACP or the ACLU or Heritage Foundation that may litigate in their own name, but also do advocacy. Frankly, the Wall Street Journal and the New York Times both have law departments and litigate cases in their own names, but also are publishers. Here, where the conduct at issue, the publication, the investigation and publication of newsworthy information is separate from any legal proceeding or client work that the Southern Poverty Law Center was doing, we submit the district court was precisely right in saying that there was no heightened, free-floating limitation on its speech arising from the fact that it engages in some litigation. I don't know that I need to say a lot about the issues of public concern. Here, They seem fairly straightforward. This, as I mentioned in my outset, this is an organization that is well known and has been adjudicated as well known throughout this country as an organization that has espoused violent and racist beliefs and that has inspired acts of hate, violence, and terrorist attacks, including the bombing of the Oklahoma City Federal Building. The New York Times did a story 2 weeks ago about the founder of the National Alliance's book, which is a Bible for the right called the Turner Diaries, including a section on storming the Capitol and hanging lawmakers that has become popular in the right. This is a matter of public concern for the original 2015 story that this organization was trying to reorganize. This organization was trying to resuscitate itself after having largely fallen apart. In 2016, it's a matter of public concern that a public official, especially a public official involved in civil rights claims, had been associated with this group and raised questions about that. Mr. Allen mentions that he was simply a contract attorney, but he pleads in his complaint on Joint Appendix page 32 that he expected to become the chief city solicitor in charge of appeals. He was on his way to bigger places within the city of Baltimore. And so I submit that this is clearly a matter of public concern, at least on par with teacher salary negotiations in a high school that was at issue in Bartnicki.
Okay, but Mr. Bowman, your position, would it change at all if Mr. Allen had not had other aspirations? In other words, if he were just a contract employee, is it your position the fact that he was actually being paid by the city of Baltimore is what created the basis for you to make the statements you did about him?
I think that for purposes of evaluating the Bartnicki issue, the issue is, were the documents a matter of public concern when they were turned over in 2015? And that related to the National Alliance. A year later, I do think that the fact, as the Supreme Court said in Rosenblatt, the qualifications of officials in public office is always a matter of public concern. I think the fact that he was prosecuting on behalf or defending a lawsuit on behalf of a government entity was sufficient. It makes it even clearer that it was a matter of public concern, that Mr. Allen has pleaded himself that he was on his way to bigger things, and that the type of cases he was working on created real issues or questions about whether it was appropriate for somebody with this background to be doing that work. Mr. Allen also mentioned the Food Lion line of cases. That line of cases, as well put in Food Lion, was about publication damages that arise from speech. You can't bring a claim, call it something else, calling it intentional infliction of emotional distress, as in Hustler versus Falwell, calling it tortious interference, and essentially seek the same damages to reputation that you would seek under a defamation claim, except if you meet all the requirements of defamation law. And although the complaint argues, or the briefing argues, that the plaintiff here is not seeking reputational damages, the complaint makes clear that all of the damages flow from the 2016 story. It's not, as in Cohen versus Cowles, a situation where someone had made a promise to Mr. Allen, the Southern Poverty Law Center had made a promise to Mr. Allen that it broke. The damages allegedly arise from publications, the effects that flowed from the publication of information. And because it was truthful information, you can't support a defamation claim. That also means you can't seek those same damages through any other tort.
And counsel, with regard to the loss of employment claim that Mr. Allen makes, I think in count 4 and maybe elsewhere, if the complaint had alleged that in addition to the publications that representatives of the defendant called the city of Baltimore or sent them letters or emails and advocated that Mr. Allen be terminated, would those acts be separate and sufficient to have sustained a claim outside of the publications? I realize that's a hypothetical because I don't think that's in the complaint, but if there were other acts that were not part of the publication.
It depends on the nature of those acts. I think you're right. I think the complaint doesn't allege any further acts other than the publication. And I think that if there were other acts that were illegal or that were improper, that could sustain a claim. But simply writing letters and saying, we urge you to, to fire this person, I think that's protected speech. And so I think that your hypothetical, if Southern Poverty Law Center had, in addition to publishing a story, had posted a petition or had sent a letter, I think that would still be protected by the First Amendment. I'll say just a word. I know I only have a couple of minutes left about the count one, Your Honor, that you had questions about earlier. Our position is that the 28 U.S.C. 2201A, the declaratory judgment rule, and the IRS rule 26 U.S.C. 7428 are this claim. Plaintiff largely relies on two strands of authority. One is the McLaughlin case, which predated the IRS rule and also predated the Supreme Court decision in Bob Jones University versus Simon that found that issue not proper for.
Well, it may be just an academic point, but I'm not sure the district court was correct here because as I read the complaint, there's not a suggestion to restrain the assessment or collection of tax. If anything, it would be to augment the collection of tax. And there are a number of cases, assuming they're standing, that permit a plaintiff to go forward. So I think the district court's reasoning here is not necessarily correct, though certainly the result may be based on a different circumstance.
Mm-hmm. Your Honor, the 2201, the Declaratory Judgment Act, says that declaratory judgments may be brought except with respect to federal taxes other than actions brought under Section 7428. Section 7428, which was a 1976 enactment, says that there's a specific procedure regarding determinations of the, quote, initial qualification or continuing qualification of 501c3 organizations. And so I understand your position. We would respectfully suggest that a declaratory judgment about whether the continuing satisfaction.
We don't have positions, counsel. We just ask questions.
Certainly understand, Your Honor. I see my time has expired. I'm happy to answer questions if the court has it, but otherwise I will rest.
Were you in the middle of answering the question?
I think that answered it, Your Honor. Thank you.
Okay, thank you very much. We appreciate your argument. Mr. Vallon, do you have a rebuttal? Mr. Allen, do you have a rebuttal?
I apologize. I got a screen. Can you hear me now, Judge?
Yes.
Yes. A number of things that Mr. Bowman said I would like to respond to. He said that the 2016 article did nothing more than ask a question. It did a lot more than that. It strongly implied that I was an incompetent lawyer and an unethical lawyer who shouldn't be working on the Burgess case. And I would add that when the SPLC got around to writing its hate map, it claimed credit for getting me fired. It said, because of our investigation and expose, he was swiftly fired. So it was boasting that they were the cause of my getting fired. They weren't asking simply an innocent question. Mr. Bowman repeatedly cites the New York Times and to other things that are way outside the record. I don't know how to fend off this. If I could get into discovery, I think I could show, for example, that this allegation that the National Alliance was involved in the 1996 terrorist bombing. I understand the impact that must have on you. I think that is an outrageous statement. And to ascribe it to me by guilt by association is completely contrary to the spirit of Kayeshan case that I mentioned. Since Mr. Bowman has gone way outside the record, let me mention that as a matter of fact, Ms. Byrick did call. It's not in my complaint, but if I had the opportunity to file an amended complaint and it was relevant, I could point out that she did call And not only this idea that this was simply asking a question, and this is in my complaint, she orchestrated a media furor over it. She orchestrated dozens of newspapers to carry this article. I had multiple calls. I had reporters in front of my house. This was a hit job, really, and it wasn't just asking an innocent question. Mr. Bowman also seems to suggest that the fact that the SPLC is a law firm is irrelevant, but it's relevant in a couple of ways. It's certainly relevant on my defamation claim. I mean, if a law firm says we've investigated so-and-so and found out that he's infiltrated the city government, that's different from some guy on the street just using loose language. There's the gravitas to an SPLC, especially when it's a 501c3. So it does matter that they're a law firm. And also, relating to the balancing, Mr. Bowman, if I understood him correctly, said that Justice Stevens seemed to suggest that there wasn't a balancing, but that's not correct. I mean, if you read the first paragraph, he talks about a balancing of multiple acts. And if you're going to balance, I think it's a relevant factor that the party involved has special obligations, as in the Boyner case. They have special obligations as a law firm and as a 501c3. With respect to whether receiving stolen property was something that was countenanced by the Bartnicki appeal, the Bartnicki case, I would respectfully refer the case to the court to footnote 19 of that opinion. And it says, our holding, of course, does not apply to punishing parties for obtaining the relevant information unlawfully. It would be frivolous to assert, and no one does in these cases, that the First Amendment, in the interest of securing news or otherwise, confers a license on either the reporter or his news source to violate valid criminal laws. Although stealing documents or private wiretapping could provide newsworthy information, neither reporter nor source is immune from conviction for such conduct, whatever the impact on the flow of the news. And they cite to Brandsburg, that's footnote 19. And I also would refer the court to this Galbat's case, which is an interesting case because it has some very similar issues. The Council on American Islam versus Galbat's, which makes the same point. With that, I would like to conclude, but before I do that, it's just a brief conclusion. I would be glad to respond to any questions that the court might have.
Don't think we have any. Thank you very much for your argument. We appreciate it.
You're welcome.
We will take the case under advisement.
Thank you.
Thank you. I think with that, court is adjourned for the day. We have some other cases to consider.
May I close court?
Yes, please.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.